saying that, oh, it's $250,000. Well, you know what? Let's address, let's address that issue in a, can I be candid with you? I can, right? Let's be intellectually honest with respect to that point. The reality is that not many people actually were aware or are aware, even today, that the government currently has a threshold, right, with respect to the amount of foreign investment that it would really. That there are opportunities for Bahamians in this bill. But we gotta see it now. Here's the point. You as a Bahamian today, if you've got an idea, right? You have an idea and you need help, right? You need some foreign expert, perhaps you need it. Why not? Why couldn't you need it? And you need that foreign expertise. You can now get, you can use this document and you can go around the world. You can take this to this document anywhere in the world yourself and market it and say, listen, foreign investor, why don't you partner with me and let's do something in the Bahamas together. Look at what we are offering. The very last thing that I want to say to you is this. Many persons have said, and I believe that on this point, they're correct, that it would have been more prudent for the government to come out with a policy, with an investment policy that was targeted to Bahamians very, very clearly, in a very clear way. I believe that. I accept that. But let me say this. As chairman of the Bahamas Development Bank, I can tell you that the government is intent on providing opportunities for local entrepreneurs, and I believe that that is going to become very, very clear in January 2018, and I'm excited to be a part of that effort. Thank you very much.
Thank you very much, Mr. Nairn. I'm sure there'll be some questions for him at the end. Our next presenter is Mr. Edison Sumner. Mr. Sumner is a Director and Chief Executive Officer of the Bahamas Chamber of Commerce and Employers Confederation, where he is responsible for the daily operations and management of the Chamber. Mr. Sumner currently serves on several boards, including Deputy Chairman of the Bahamas Entrepreneurial Venture Fund, Deputy Chairman of the Bahamas Bureau of Standards and Quality, Chairman of Veritas Consultants, member of the National Tripartite Council, member of the National Economic Advisory Committee, director of the music project, etc. There's a lot that Mr. Sumner is involved in. And that's literal, actually, because I tell you, he's a difficult guy to catch up with. Mr. Sumner received his education and training at London Guildhall University and City University, London, England. He also holds numerous professional and academic qualifications. In 2016, Mr. Sumner was appointed Justice of the Peace of the Commonwealth of the Bahamas, and in 2017, he joined the Honorary Consular Corps as Honorary Consul for the Republic of Namibia in the Bahamas. Mr. Sumner is also heavily involved in the civic and cultural communities as one of the Bahamas' leading gospel music recording and performing artists, and also serves as a leader in his local church. Mr. Sumner is married to Darlene Noel Sumner, and they are the proud parents of one son, Avery Dawson Sumner. It is my pleasure to present to you Mr. Edison Sumner.
Good evening, everyone. So I think I want to thank Mr. Storr for inviting us to be a part of this panel this evening and to take part in what has become, I guess, the most exciting topic to hit the Bahamas in the last 2 weeks. And I say 2 weeks because, things change so rapidly around here. But in order to stick with my time, because I know he's given us some strict timelines, I would just I'm going to read two releases, two pieces of two positions that we released on this bill. One of them was on the first draft of the bill, or the first tabled draft of the bill, because I'm sure there were several iterations before it got to the House of Assembly. And then I'm going to read a release on the amended version of the bill, the one that actually passed Parliament last week. So please beg my indulgence. I only got about 47 pages or so. No kidding, it's actually just 4 or 5 pages. So on the 23rd of November, which was the week, a few days after the first bill was tabled and debated in Parliament, it said attracting foreign investment and the development of certain sectors in the economy is essential to the growth and development of the economy and is fully supported by the Bahamas Chamber of Commerce. The bill can be seen as an interim solution for businesses in certain industries with a foreign ownership component to navigate the process for obtaining investment board approvals and work permits. The Chamber applauds the creation of a commercial enterprises facilitation unit and hopes that it will include representatives from the private sector. However, we wish the attraction of foreign investment to be balanced with the support of local businesses, particularly the small and medium-sized enterprises, which are the backbone of the local economy. Wholly owned Bahamian businesses are not currently required to apply for an investment board's approval, as Lyndon just said. But in order to take advantage of the benefits of the bill, or the benefits that are contemplated in this bill, a newly established, wholly owned Bahamian business would be required to apply for approval from this new facilitation board. So it's important to understand that notwithstanding the industries that are highlighted in the Schedule A of the bill, because you belong to that industry doesn't automatically mean that you have a right to the provisions of this bill. You have to apply for a certificate, a specialized certificate in order to qualify for the provisions of the bill. Accordingly, in parallel with the initiatives outlined in the bill, which are aimed largely at foreign investors, and that has changed, and I'll come back to that in a moment, incentivizing Bahamian businesses in these sectors and addressing the ease of doing business is also of paramount importance for the growth and diversification of the economy. Further, the cost of labor, capital, human resources, and energy are higher in the Bahamas than you would find in other areas in the region. Bahamian-owned business in certain sectors, example, mutual fund administration, wealth management, boutique health facilities, will be disadvantaged and will not be able to compete. For example, a foreign-owned business which is a non-resident for exchange control purposes, pays a nominal business license fee or business license tax, whilst a Bahamian-owned business serving the same non-resident clients must pay business license taxes on their gross turnover, whether or not that business earns a profit. With regard to the provisions of the bill itself, I'll make just a few observations. One, it is unclear in the initial bill, it was unclear whether the bill is intended to apply only to businesses with a foreign ownership component. And I'll come back to that again in a moment. To the best of our knowledge, trade on boutique health facilities. If you look at a boutique health facility, for example, if one were to invest $250,000 to set up a doctor's office with 2 physicians, the question is, would that be considered a boutique health facility? For a company applying for a specified commercial enterprise certificate, that is a services-based entity that might not require a significant amount of capital to structure that company. The question is, what constitutes the $250,000 investment in that company, in that enterprise? In light of the application of the bill, in its current form to businesses which are partially or fully foreign-owned, the minimum threshold might be too low for international companies wishing to establish a commercial enterprise in the Bahamas. And we know that in the revised bill that has been addressed, and I'll come back to that momentarily. And perhaps an indication of general concessions, because there are going to be concessions offered at some point at the discretion of the board or the minister. Perhaps an indication of general concessions that may be considered should be clearly articulated. It will be important that there is no perception that, apart from comments that we made in paragraph 4 just above, that any particular applicant is receiving advantageous treatment over another. 7, from a drafting perspective, there are some sections like section 6.1, which refers to senior management and in-house professionals, while section 7.1b refers to executive, manager, or individual with specialized knowledge relating to the enterprise. So there has to be some clarity there, we think. The terms senior management, executive, and management are very subjective. We would recommend that the bill be limited to senior management and in-house professionals as contemplated by section 6.1, that senior management be specifically defined to include personnel at the managing director level or higher, and that is also that section 7.1b in the bill would be amended accordingly. If the specified commercial enterprise certificate is only valid for 1 year, why grant a work permit for 3 years, as in section 8.4 of the bill, with an option to renew for an additional 3 years? There should be some level of consistency in the term and tenure between the granting of a certificate and work permits. 8, there appears to be conflicting details with sections 8.1, 2, and 3, and should the approval of a work permit accompany the application for the certificate, since the certificate process is a vehicle for attracting such companies and individuals. And finally, in this section, based on the initial bill, the person covered under the specialized certificate can enter the Bahamas, as we've heard Merritt say, without a work permit, even after an application for a permit is submitted. If they do not hear from the Director of Immigration within 14 working days, their work permit is considered to have been approved. This provision will cause for there to be, we think, greater expediency and certainly greater efficiency in the work permit approvals process. But our contention is that we would like to see that the same level of expediency that is applied to granting a work permit, essentially in 14 days, also be applied to other areas of government services. So if we can do this in 14 days to grant a work permit and the director doesn't respond, then certainly we should be able to provide the same level of urgency in other government services as well. That's been one of our major issues. Now, post the amended bill, I've got three pages I want to just read quickly for you as well. This was, we released this just earlier this week, I think the day or two after the bill was passed in the Senate. So, the Commercial Enterprise Bill 2017 passed the House of Assembly on the 4th of December 2017 without further consultation with the private sector. However, we know that there were some material amendments to the bill, particularly Section 4, 1, and 6, which deals with specified commercial enterprises, which now addresses the issue of Bahamians qualifying for a specialized commercial enterprise certificate, and which seeks to define the term Bahamian and non-Bahamian in the bill. There is a school of thought that even the definition of Bahamian in this bill, even though referencing the Companies Act, may be too ambiguous for the bill and could provide an opportunity for foreign persons to take advantage of what could be considered a level of ambiguity for the purposes of this bill. Bahamian is defined as a natural person, which is too loosely defined. The definition of Bahamian in this bill should be a natural person holding Bahamian citizenship. Just saying a natural person is not enough, and that we see it as being could become a significant loophole. Two, the amendments to the bill, which are clearly intended to allow Bahamians now to take advantage of the accelerated immigration process contemplated by the bill, are to be applauded and commended, and we do so. And so we commend the government on at least moving that part of the amendments forward. Three, further, the threshold of $250,000 as a minimum investment requirement has been removed for the Bahamian enterprise, but it remains in place for the non-Bahamian enterprise. In addition to Bahamians, the $250,000 investment threshold does not apply to joint ventures or partnerships between Bahamians and non-Bahamians. So I heard Lyndon saying we can use this bill to go and shop it around and attract joint ventures, but if you are attracting a joint venture to come in to apply for commercial enterprise certificate, then you disqualify yourself from that zero rate that is required to apply for a certificate once there is a joint venture and there's a foreign component as a part of that joint venture. So we're saying that in the absence of a definition of a joint venture, because it's not defined in the bill, that the concern is that a joint venture with a Bahamian could be contrived to avoid the $250,000 threshold. And this could be easily defined or addressed if we were to put a definition of what a joint venture is in the bill. And that can, I think we can take care of some things with a definition. For the purpose of the legislation regarding joint venture, a Bahamian is defined as a company with at least 60% Bahamian ownership. Theoretically, this means a 60% Bahamian-owned company can joint venture with a foreign company for only 1% in the joint venture. And this, therefore, there is, therefore, no minimum ownership required for joint ventures, at least not articulated in this bill. 5, I've only got a few more left. I'm almost out of the way. Notwithstanding our position that the minimum threshold of $250,000 for foreign direct investors was too low, a number of the businesses in the schedule may not even require as much as $250,000 startup capital to establish their businesses in the Bahamas. And I talked about the services business a few moments ago. So while we understand and appreciate that the objectives of this bill are, among other things, to promote foreign direct investment, job creation, and encourage qualified Bahamians to return home to establish new businesses, we contend that the minister should have a level of discretion already provided for in the bill to consider applications for specified commercial enterprise certificates for investments in specified economic zones, particularly islands outside of the Providence, below the $250,000 threshold, where a minimum of 20% permanent and sustainable jobs will be created and guaranteed for the Bahamians for the life of the specified commercial certificate. And that after the first expiration of the work permit, which is granted for up to 3 years, that Bahamians would have been trained and skills developed to take over certain roles in the enterprise for which work permits would have been previously required. And this must be demonstrated, there must be a demonstrated commitment to the training and development of the local workforce. And that is provided for in the bill, if I'm not mistaken. I believe Merritt mentioned it when he spoke earlier. 6, notwithstanding, it is essential that the government of the Bahamas institute programs and facilities to cause for the further training and skills development of the workforce in the country to take advantage of opportunities that may be presented by commercial enterprises, such as access to advanced training in information, communications technology, and science, technology, and innovation. In Section 7.2 of the bill allows for the certificate holder, upon application, to either extend or renew his certificate, to amend or vary his business plan as may be agreed between the certificate holder and the board. This might not be a material change, but given that the minister can amend the industries in Schedule A as he deems necessary, this proviso might create a loophole for applicants to apply for a certificate based on an amended business model that is foreign to the original business certificate granted. Now, we gave 4 recommendations, and I'll read them out very quickly. 1, we recommend that the annual renewal of the enterprise certificates be tied to a review of the business plan to ensure that the business for which the certificate was granted was actually being conducted, and that Bahamians were still permanently employed and being properly trained in specialty skills. Further, we suggest that the purpose of any review be intended to measure the degree of investment against the concessions provided. This should not be specific or limited to immigration. Furthermore, certain concessions should be performance-driven and tied to a specified expectation and outcome. If the purpose for which the concession was granted does not materialize, then the concession should fall away. So if we gave you land, for example, to do a certain thing, and you use the land to build something else on it, then the government should take the land back because you're not using it for the purpose for which it was granted. Also, when we consider the definition of investment under this bill, and that is cheek and tongue because there is no definition of investments in the bill, one has to also consider the regulatory threshold requirements for certain industries and whether the limits being imposed in the bill are consistent with the requirements of specific industries. For example, if the regulatory requirement for setting up a captive insurance is, say, $100,000, I'm not sure if that's the number, would that be considered part of a $250,000 threshold, or would the applicant have to satisfy both the $100,000 regulatory requirement and another $250,000 for the certificate? It is our view that the regulatory capital should not be taken into account for the purpose of calculating the $250,000 minimum threshold. Merritt's on the edge of his seat, so I know he wants me to get off the mic. I'm done now. So, in considering the way forward, we took a position that there needs to be substantial overhaul and reform of the policies and procedures in the Immigration Department, the Bahamas Investment Authority, and the investment policy of the Bahamas should be clearly and comprehensively articulated. Further, the bill should go hand in hand to support other existing legislation, and that there needs to be a complete overhaul and reform of the laws, policies, and procedures that seek to attract foreign investors, as well as support the local domestic investor and the local business community. We strongly urge the government to increase the efficiency of all government agencies to facilitate expedited processing of regulatory applications throughout the government systems in the same manner contemplated by Sections 8.2 in the bill, which mandates that the determination of any work permit applied for should be responded to within 14 days. And finally, my last point. We also recommend a review enhancement and streamlining of the framework that supports small and medium enterprises in the Bahamas to ensure that they are in a position to significantly contribute to the Bahamian economy. Additionally, the ease and cost of doing business by Bahamian SMEs should be addressed as a matter of priority, with due consideration for concessions, incentives, and access to capital for this very important sector of our economy. However, this issue is much more complex as energy reform, fiscal policy, monetary policy, and other issues will play a major and significant role in addressing the dilemma facing small businesses in the country today, and we encourage the government to continue working closely with the private sector through the Chamber of Commerce to facilitate the ease of doing business in the Bahamas. Thank you.
Thank you very much, Edison. Now, in fairness to Edison, he tried to pack in to 10 minutes, probably a 30-minute presentation. But what I would like you to see is that the Chamber of Commerce has really done a lot of work in reviewing the details of the bill. And if your first introduction to the bill is what I presented to you this evening, then it may have been a bit difficult to follow everything that Edison said. But they have gone through the bill line for line. And the good thing about it is that the Chamber of Commerce, their sole purpose is to protect the interests of Bahamian businesses. And so that's been their particular focus in their commentary. So if the technicality of some of the things he said, you didn't follow everything, don't be discouraged. As I said, the bill is very simple. It's like a 5-6 page document, not difficult to read at all. And I would encourage each of you to get a copy of it. And so our final presenter for the evening is the Honorable Ellsworth Johnson. And Mr. Johnson obtained his law degree in 2001 from the University of the West Indies and a legal certificate of education in 2003 from the Eugene DePuch Law School. He was called to the bar also in the same year, 2003. He also holds a master's degree in corporate and commercial law. He is the immediate past president of the Bahamas Bar Association. He's a former acting director of the Legal Aid Clinic, this may be a trivia question at some point, a former constable with the Royal Bahamas Police Force. I don't know how many people know that. And he was just this year elected as the Member of Parliament for the Yamacraw constituency. He was subsequently appointed as Minister of State for Legal Affairs in the Office of the Attorney General. I'll also add, before I say one last thing, is that in the past, he's been a friend of Bahamas Faith Ministries. We've done some legal clinics here at the ministry, and we partnered with the Bahamas Bar Association, and at the time, Mr. Johnson would have been the president of the bar, and he would have played an integral role in promoting those events. We would have worked on promoting those events together. And so he's also an avid follower of Pastor Miles. He's married to Kathy Ann Cromartie Johnson. He has 3 children. He's a member of St. Ambrose Anglican Church, corner of Carmichael and Gladstone Road. He tells me he sings in the choir. I don't know how well, but he sings in the choir, and he also acts as an usher. So it is indeed a pleasure for us to welcome the Honorable Minister